Welcome, everybody, officially to the webinar. I'm Mark Murrell, co-founder of CarriersEdge. I am joined today by Rick from our marketing communications team, who is gradually taking over the webinar program from me. And our guest today, as everybody knows and is obviously very excited by, Kevin Mulvaney, partner with Wilson Elser law firm. And Kevin, you're based out of Detroit area?
I am.
Okay, yes. This is a session I've been wanting to do for quite a while. I'm going to start off with a bit of a disclaimer. Often when we're doing these kind of sessions where we're getting into things, we want to make sure that everybody is aware that we're not offering anything here that should be considered actual legal advice. No attorney-client privilege has been established. There's no relationship here. Do not take anything that we say too seriously. Well, take it seriously, but don't rely on it. Talk to your own counsel about any of the things that come up here. All of the other normal disclaimers that you might imagine, we should be adding on here as well. We want to get into this, but we need to make sure everybody is aware of what we're doing here. We're just having a light conversation about things that Kevin has observed, some questions that we see coming up. We'll go through those. You all can ask questions if you like as well. We will try and work them into the conversation or get them answered at the end. And as you all know, it's being recorded, so you get copies of the recording afterwards. So I think that's it for the disclaimers. Kevin, anything else that we need to include there before we get into it?
All set, Mark.
Okay, excellent. One other thing. I have to make a plug for Best Fleets to Drive For. The nominations are open. I see lots of people registered that are familiar with the program, but Best Fleets to Drive For is open for nominations now. The 16th edition of the program, and making me feel super old that I've been doing this for 16 years. Nominations open through Halloween, so spread the word to your drivers, or if you're on the risk consulting and insurance side, let your customers know about that. We'd love to get lots of fleets involved. So this particular session is actually something that kind of grew out of some Best Fleets observations and many of the events that I have gone to over the years, safety conferences and things where we have lawyers talking about things that they're seeing. It's often, we all love the war stories from court cases and digging into all of that stuff. But often what happens in these discussions is the lawyers talk about the things they like to see, the things that cause problems. And there's a lot of make sure you train your drivers, make sure you document that training. And then it kind of moves on from there. There's not much more than that. But I knew there had to be a lot more underneath that. It's not as simple as just training. When the box is checked, training is done, okay, everything is good. There has to be more to it. So I wanted to dig into this. And Kevin has agreed to talk to us about that a little bit more specifically. So I know there has to be a lot to it. I know there is going to be good and bad out there. And what I wanted to do today is go through kind of what you see as best practices, what you see as gaps. And one of the things that we talked about when we were prepping this a couple of weeks ago is the idea of kind of constructing the ideal training program to minimize potential problems in court. So as we go through the discussion today, what we want to do is try and put some of the pieces together that gives people that ideal model that they can follow down the road. So let's start with some of the top things that you see in your practice as gaps or problems, things that come up that people get bit by in the legal sense of it related to training for their drivers.
Yeah, thanks, Mark, and thank you, everybody, for attending today. So taking a step back, what I'm really seeing, you might have heard the phrase nuclear verdicts or shock verdicts. That's defined as any verdicts that's over $10 million. Unfortunately, it's only getting worse, and now we're talking about super nuclear verdicts.
Ooh, super nuclear. Yeah.
So 10 million, you can't brag about that anymore if you're a plaintiff's attorney. Now you're talking about 100 million plus. And with these verdicts, there's some common threads that we're seeing. And it's going to be some really important takeaways for the folks attending today with respect to training. The first and foremost is whatever fleet you operate, whether it's one unit or hundreds, make sure that you are implementing a safety program that you can implement and follow. There's nothing worse as a defense attorney. I defend trucking companies all over the country. There's nothing worse than trying to spin a policy that the company created for itself and then violate it or then failed to follow or whatever it might be. The FMCSR is there as essentially your benchmark, and it's fantastic as a defense attorney for companies to implement above and beyond that. Quite frankly, you should, but you need to look in the mirror and make sure it's a system and it's policies that you actually can employ, and not just theoretically, but you've got the right people working with you to actually handle whatever it is that you're doing.
So that is something that I think is important for fleets of all sizes. And that's a really basic piece, because everybody thinks that setting up policies is sort of a starting point. And okay, I got the policy, we do this, and this is what our policy says. And we see that in the Best Fleets program, that fleets say, well, yeah, we got policy on this, policy on that. Okay, well, what do you do with that policy, right? Or are you actually looking at it again? I think that's where the challenges come up, is if they say they have a policy, I guess what's going to happen is that plaintiff's attorney is going to say, okay, well, let's have a look at that then. They're going to start digging into it and starting to look at places where maybe it wasn't followed. So you had talked before about sometimes small fleets set themselves up for failure by having too many policies that they just can't follow. So is that something that you see there? They go too far down that road of just setting up a policy?
It absolutely is. This is not a one size fits all industry. So whether that is, let's take a smaller one or two units, and they have worked in the industry, and they've gotten to know safety directors from other motor carriers, and let's say they start taking policies from a motor carrier that has 2,000 units. You can only imagine all the overkill, quite frankly, for a 2-unit motor carrier versus 2,000. So it's great to be proactive and try to collaborate with colleagues within the motor carrier industry to do those things. But what are you actually implementing? And going back to, as the defense attorney, if I have to turn over all your policies and then we have a frank conversation before a deposition or even before the lawsuit is ever filed, and we're looking at these things and we're seeing that, all right, you might not have done your refresher training, or you might not have done this or that, and that's the driver who was involved in an accident where we actually could defend the case quite well on liability. It wasn't your driver's fault. A jury doesn't really care about that. Jury trials are popularity contests. So if a plaintiff's attorney is able to say that you had these policies, you didn't actually follow them, they're going to go to what's called the reptile theory. And not to belabor the point, but the whole idea about reptile theory is profits over safety. So the motor carrier was doing something such as not actually following their own policies. Instead, they want to get the drivers on the road without actually checking all the boxes. That it's a home run for plaintiff's attorneys. And when we see these nuclear verdicts, it's this profits over safety theme that plaintiff's attorneys just they keep hitting that bell over and over and over, and it makes the jury hate the motor carrier, even though the motor carrier tried to do their best, but they set themselves up for failure.
Now, what I hear a lot of fleets taking away from those kind of messages is the importance of providing training to drivers when they first start, that orientation stuff and documenting everything that's happening at orientation. But you had made the point before that when we were prepping this, that's not enough. It's going to be, related to anything that happens afterwards as well, that we need to consider all of that. And talk a little bit about that, what you see there.
Yeah, look, it's a tough industry out there as far as driver retention. And so, if you're able to keep drivers on for years and everything like that, I mean, let's say you've got a million miler who hasn't had an accident, but he hasn't actually had any training since he started. And that was 15 years beforehand. The technology's changed. The regulations have changed. Just the industry and the world has changed. So even if you have somebody who's never had an accident, if their first accident is a catastrophic one,
Hmm.
let's go back to the plaintiff's attorney, and he
Right.
can say this company chose not to do any sort of training for this driver for 15 years.
Right.
That's troubling. So you keep thinking about what's the jury going to hear, what's going to really anger this jury who already doesn't want to be there, quite frankly. So what can they really hang their hat on when they're deciding how much money an injured person or the family of a deceased person or persons is entitled to?
Hmm.
Mark.
Hmm.
There is a question in the Q&A, or was, whether or not this is based on US or Canadian law. I think more to the point, it's about navigating the legal landscape,
Yeah.
whether those apply to each one. But a question for Kevin: if I'm a small fleet, very small, and I just, I can't do all the things that the large fleets can do, but we've got to go into a deposition. Would you rather see me with a very pared down sort of training schedule that maybe I could follow, or something more robust, but maybe I let slip on a couple things? Because it seems like a plaintiff's attorney could spin either of those.
Right. Well, so first, Rick, to directly answer the question posed, this is coming to Canada. So
Mm.
my communication with attorneys, especially in Ontario, it might not be next week, it might not be next year, but this is something that is going to be coming across the border more and more, as far as these types of things that we're seeing in the U.S. Rick, back to your question, paring it down, quite frankly, is fine if that's all you can do. And it all comes down to what can the motor carrier actually do. I know of some very large motor carriers that have, quite frankly, small programs, because that's all that they know when they looked in the mirror that they can implement. However, that gets very difficult to defend, especially in states with punitive damages, because the plaintiff's attorneys will then hire these safety experts who are some of our former colleagues, and now
Mm.
they're hired guns. So it's a bit of both sides of the coin to your question, Rick, of what you should do. It's really going to have to be a customized approach to each fleet, and obviously the more they can do that they can actually implement, the better.
Hmm.
Because the big
Yeah.
thing is, as the defense attorney, I have to tell a story at trial as well, and I want to
Hmm.
show that this company is safe as possible. Um, but I need to do that knowing that I can actually back it up.
Right. Yeah, well, I think coming back to the whole point about the policies, what I've found more successful companies do, certainly not from a legal standpoint, but from a best fleet standpoint, the companies that tend to be more successful focus less on the policy and more on a process. So they won't say, well, if you have this many texting and driving, you're cut, because that sort of zero tolerance thing always bites them in the butt later. But what they do instead is they have a process for investigating it, having a team that's part of that, and maybe a small team if it's a smaller company, but they have a process for investigating, coming up with an action plan, and then addressing it and looking more at root causes rather than just saying, we're going to hit you with a policy and hit you with a policy here. And the same thing kind of goes to training as well, is that rather than just saying, okay, we're going to have this plan where we do this and only this, that we're going to stick to this and we're going to do this basic training program, and that's the thing because we've followed our rule. The more successful companies tend to kind of step back and say, okay, well, we're going to look at our situation and plan accordingly, and we're going to have this kind of dynamic response to it. That's what I see that seems to be working for them in terms of actually improving their safety record. How does that tie in, to your job having to defend them? Does it help or does it hurt?
It really helps, Mark. The proactive approach. I'll give you a perfect example. So, if there is a U.S. lawsuit, one of the first people that the plaintiff's attorney wants to depose is the safety director.
Mm-hmm.
I have had very large LTL clients where the safety director was deposed, and they were talking about their coaching.
Mm.
And we're talking about not an accident coaching, but anytime there's a hard break or whatever it might be, and how it was implemented all the time. After that deposition, it went so well. The plaintiff's attorney was so impressed by the safety director that he essentially admitted that he was no longer going to be pursuing the negligent training and supervision type of claims, and we could really pare down the case. I wish all cases were that easy, quite frankly. But if you're gonna have a safety department that's proactive and is going to customize it to what they're seeing with the root cause analysis, whether it's accidents or where they're seeing their DOT violations, that's paramount.
Yeah. Okay. Well, that really ties in nicely to what we recommend. So I'm happy to hear that. Happy to hear that we recommend that people do the training, but then follow up with it afterwards, talk to the drivers about what they did, discuss the results, all of that kind of thing. So yeah, that's really good to hear. We have a question here that I think is going to lead me into a couple of different areas. So we have a 100-truck fleet. Do you feel we should have a full-time trainer? My thought would be you definitely need a full-time safety person and probably at least one trainer. From a legal standpoint, that seems like it would be hard to defend if they didn't. Would you say that would be a challenge for you if a fleet of 100 vehicles didn't have dedicated training resources?
It would be very difficult. Going back to these hired guns that plaintiffs attorneys will hire, who are former safety folks, they'll identify that right away as a red flag.
Right.
So, I wouldn't just leave it there, right? Look to your most senior drivers, who at least part-time, can be mentors and can provide whatever service they can. I mean, understanding you have a business to run, and the time that they are not on the road delivering freight hits the bottom line. But big picture, is if some of the training that they did not provide to more junior drivers is what caused a real significant accident, that 1 or 2 loads a month they didn't run, it's kind of a drop in the bucket.
Yeah. Well, I've also heard other attorneys say that a lot of the time it comes down to, whether the company is trying to, I forget the wording this one guy used. It was so perfect, but are they trying to build a good community in their workplace? And so if you've got the senior driver that you're using to do coaching, and having that person share their expertise and using it as a way of doing not just road training, but helping the juniors to get up to speed, but also giving better quality of life to the senior drivers so that they're more engaged, and you've got a more integrated community within the organization, that those tend to be the stories that actually work in the fleet's favor in front of the jury, because it looks like you're trying to do the right thing. You're trying to build the better organization, and it isn't necessarily the best, the most cost effective in the short term, but over the long term, you're tending to kind of build a stronger community. Is that the kind of thing that you've seen as well?
Yeah, look, accidents happen. There's not always someone to blame. But going back to something I mentioned a few minutes ago, a jury trial is essentially a popularity contest. So if an accident happened and no one's really at fault, but if there is a company that I'm defending that I can really be proud of defending because of everything that they did to prevent that from an accident happening, which is all it is, from telling their story, that's what makes my job a whole lot easier. And that's what really resonates with juries all across the United States. If they see a company that was doing everything in their ability to make sure that they were sending out safe drivers, and just simply an accident happened, that's the type of trial where you're not going to expect the nuclear verdicts that I was mentioning beforehand. It's when you get those really bad facts where they were ignoring all these things. They were pushing their drivers. They were trying to cut corners on safety. They had loads that had to get delivered, and maybe they had some folks that they hired that had questionable MVRs. I mean, those are the types of things that I see that are really troubling.
Okay. So I see there's a question there. I'm going to come back to that in a little bit, but you're talking about cutting corners, and this is another area that I wanted to go into was looking specifically at the training content, because it's one thing to say, okay, we do this training, but we also have to assume that people are going to look at what that actual training is and what the quality of that content is, and dig into it from there. So talk to us a little bit about what you see a plaintiff's attorney doing when they're looking through all of those things to try and find gaps.
Sure. So going back to the experts that they use, they're essentially given a playbook. by their experts to start looking for different types of things. So whether it is the frequency of the training, the scope of the training, or it's somebody who's quite frankly just not completing it.
Right.
But also it's what type of training. So the type of cases that I run into, we're talking about defensive training. We're talking about not even in the truck, warehouse safety, high-low safety, hazmat safety, things like that, where, quite frankly, just think about the type of training where bad things could happen and injuries could occur. Obviously, we're in September. The winter will be here before we know it. So, wintry conditions training, things like that, and then refreshers when appropriate, to take care of those different types of things. I have a client here in Michigan that they have refresher training every year around deer hunting season, because they know there's gonna be deers all over the place, and the last thing they want their drivers to do is to make an abrupt move with their steering wheel to drive into somebody. So it's knowing where your folks are driving, especially if it's cross country, and making sure they're planning for their trips and they know how to get around.
Right. Okay. So anything that is going to suggest the company is trying to save a buck at the expense of safety is going to be a problem for them. So I'm assuming that things like going and finding like free training on YouTube and using that for your drivers, or having a training program, but you only put a small portion of drivers through it because you don't want to pay for everybody, that stuff is just going to kill you, I would imagine, in court.
Especially that second part. If you're cherry picking who you're sending. That has trouble written all over it. YouTube's a problem. I've heard about ChatGPT and just and everything that we're hearing about now, that somehow getting into training. I can give you a quick story. There are two attorneys in New York who decided to use ChatGPT to write a motion for them, and the bot created case law that doesn't exist. So they are all over the internet about the cases that they cited, and I'm sure that's also leaking into the trucking industry when it comes to training and everything like that, where it's probably pulling information from different places, but when you put it all together, it doesn't make any sense.
Yeah. Well, we've certainly seen that, people trying to use ChatGPT to make training, but it's got a hallucination problem. You can't rely on it. And so much of the world of trucking safety isn't written down anywhere. It's so much oral tradition. This is our challenge when we're building content. We have to talk to so many different people. Nothing's written down. So I don't know where ChatGPT would even get its content from. So yeah, it's not going to be that reliable. We do have a question here, which I think speaks to whether online is acceptable or in person is necessary. And I'm doing this webinar because I have a pretty high confidence that you're going to tell me that online training is acceptable. I'm going to be in a very bad mood if you say otherwise, but no pressure. Tell us, what your thoughts are on online versus classroom.
Look, the drivers are all over the country and all over North America. So if they've got downtime, training, even their sleeper berth, I'm sure is possible, as opposed to having to have everybody in the same location at the same time. That's the way of the world. Where I'm sitting right now is where I handle most of my court hearings nowadays. So this is not just in the trucking industry, but this is just the new way of the world. And so, just ensuring that the drivers are competent in operating the computer and making sure that they're following those things is really critical for the motor carrier. But in person, that is just not the way of the world anymore.
It is not feasible. Well, the other side of it is that when it's online, you get so much more data tracking that you can work with. When it's in classroom, all you typically track is that somebody showed up, and that's hard. I mean, they often don't even really document that. So then you're stuck trying to defend it, and there's like some scribbled sign-in sheet, and you're trying to say that that's proof that training took place, but you don't know if they actually learned anything. Whereas when it's online and everything is tracked, in some ways, I don't know if it makes it easier for you. Certainly on the fleet safety side, it gives them a lot of information that they can then use for that follow-up that we were talking about later. So there's a lot of advantages there as well.
Compliance is key. When it was the old school sign-in sheet, look, I've had those cases where a buddy would sign in their other friend. They either didn't want to go or whatever it might be. And when they're asked in deposition, is this your signature? That's a problem. You can't get around those things when you have technology in play.
Yeah. Well, that's funny because that's sometimes a question that comes up with the online is, how do I know that the driver actually did that course? My question is always, how do you know that driver is driving that truck? And your example is a great one. How do you know that driver was actually at that session? They might have signed in their buddy. Yeah, so that's a good point, which is why we always say follow up. I mean, this is the thing you said right in the beginning, is talk to people and have those discussions and don't just rely on policies or rules. Okay, we've got a couple of questions here. So let's see, let's go back to the first one. Is there a standard ratio of trainers to drivers? For example, 1 trainer for every 40 drivers. Do you have anything that you go with on that, or is it more about what they're doing with that program?
No, I don't. I don't think that there should be a one size fits all policy when it comes to the ratio. It really comes.
I could see you could have you could have 40 trucks and be doing hazmat or something like that really requires a lot of diligence. And then you need multiple people that are on it all the time. Maybe you've got a small fleet that's doing something lighter and it's not in a high traffic area or something. So it could be a smaller staff. Sure, that makes a lot of sense. It's going to be more about what your plan is and what you're doing with it. Next one. Be the risks and or benefits in providing targeted training for new driver hires that may have a higher risk profile than others? Is there an issue with hiring driver companies explicitly stating is a heightened safety risk? Does the targeted training program show more robust safety culture in the company? This is an interesting one because I know one company in particular that specifically hires people that don't meet their criteria so they can test the validity of their training programs. So what's your thought on that one from the audience there?
It's a very interesting point because look, driver shortage is not something that's going to go away. So identifying drivers who might not meet criteria, if they are rehabilitated, and when they are finally out on the road by themselves, I'm assuming that would include co-drivers and things like that to bring them up to par. But I would say that there is, in theory, some really good ideas there, but that's going to have to be something you're batting 1,000 at. Because if I am defending a company and they have drivers behind the wheel that they initially identified as high risk, what are they doing? What story can I tell to show that they truly removed them from that high risk category and brought them down? So whether that's certain number of hours, whether that's certain number of ride-alongs, whatever that might be, whoever's implementing that policy needs to think about if they were sitting in a deposition and it was their deposition, how would they answer that question?
Okay. We got a bunch of them, but you just sort of
yes, we do.
It's a question. But I want to hog some of the time because I've been waiting to do this webinar for a while. You talked before about the hired guns. So you said some of them are sort of ex-colleagues. So take us through that a little bit. What does that typically look like? And what are their objectives there? And what do you do to combat that?
Sure. So this starts, quite frankly, if it's a bad enough accident, this could start the day or two after a fatal accident. The families of a deceased will hire a lawyer. You see them all over the country with the billboards and things like that. And it'll eventually get to lawyers who are very well versed in motor carrier cases. And they've got these guys on speed dial. So this will start with an inspection of the equipment, both the tractor and the trailer, or plural trailers, depending on what we have. So they're going to have an accident reconstructionist look at that top down, and they're going to find anything that might be wrong with it. So there's the equipment side of it. But more so what we're focusing on is that they will then have these fleet industry experts and safety experts who are going to give a playbook to their plaintiffs attorneys. They're going to tell them what to ask for, what to have be preserved even before the lawsuit's filed. Once the lawsuit is filed, they're going to ask certain questions to the motor carrier. Tell me about this, tell me about that. Kind of, it all will be tailored to what kind of accident occurred and what the facts were. And then that safety expert will then draft pages and pages of questions for that safety director to answer in a deposition. So as far as, what are they exactly looking for? It really depends on what happened in the accident. And then they are going to tailor it. But what it comes down to, if we're going to kind of look at what you'll see most often, what policies were in place, and again, what was actually followed. What did the company create and just not follow through on? That's huge. But then they'll also look at the size, and kind of like an industry standard approach of, if this is a larger motor carrier, they'll do an apples to apples comparison of other competitors and what their safety programs are. So that's the other thing. If, let's say you're 400 units or 4,000 units, what are your competitors doing? You don't want to be the one that's kind of identified as the redhead stepchild of that part of the industry.
I love that. So what do you do to combat that? Do you hire your own expert to come in and sort of refute everything?
So we have our own, but quite frankly, even before that, a lot of times we get involved with accidents and so I'm already starting with evidence preservation and looking at documents. And quite frankly, a lot of times, if I see bad things, I'm going to have a frank conversation with the motor carrier and their insurer that we need to settle this case before the plaintiff's attorney ever finds out about some of that bad evidence. And that might mean paying a little more. But you don't want to have, if you catch something that wasn't followed and it is something that could be considered a root cause of that accident, you don't want the plaintiff's attorney to know about it. But in any event, if we are in litigation, I spend a lot of time with those safety directors, prepping them and making sure that they know exactly how to answer questions. And I call it the Bill Belichick response, where if you ever watch Belichick after a game, he never answers the question. He never does. So there's a lot of that.
Okay. And last question before I turn it over to some of the others that have got a lot for you. You talked about 400 power units and sort of larger companies. How much is this trickling down into smaller fleets now?
It's the smaller fleets that maybe you have to worry more, because they have folks that are wearing multiple hats. So one day you might be dispatch, safety, and operations all the same person. And a plaintiff's attorney is not going to care that you are that small. He just sees dollar signs on behalf of his client. And there's no defense that I can put out there of saying, look, it was only a 2-power unit motor carrier. Sure, they didn't follow their policies, but ladies and gentlemen, the jury, are bad kind of thing. That doesn't work at all. So going back to what I was talking about nuclear verdicts, is there something out there that's going to anger the jury? And with those smaller motor carriers, if they're putting out different policies, but they're not actually going to follow it because they're so busy with everything else, they have to be mindful that they need to maybe have more folks on staff to ensure the safety is being implemented all the time.
Okay. All right.
So I'm going to get one in before I hit you with the tsunami of audience questions. I was at a conference this past week, and there was a session on depositions, and something came up about wording in policies. In particular, someone got pinched with the very first words of their safety policy, where safety is our #1 priority. Now, on the face of it, like, who's going to say no to that? But they actually got hammered on that. Why would that be a problem?
Sure. So we could spend a whole hour on the reptile theory, but what was occurring in that deposition that was being discussed is what's called the reptile theory, and the idea is profits over safety and things like that. And I'm sure the way that deposition went was, well, clearly your company didn't follow their #1 priority or something like that. So just know that in depositions, it's very difficult to win the entire case with one deposition. So if anyone that's watching this presentation is ever deposed, don't worry that you don't bat 1,000. Nobody does that in a deposition. But that's why you should have counsel who's quite frankly spending more hours with you prepping for the deposition than the actual deposition itself. And also don't forget, you're being questioned by a lawyer. This is what we get paid to do, is mince words and twist words and put words in your mouth. Granted, the deposition might not have gone so well for that speaker, and I'm sure that person felt terrible, and I'm sure he felt that he lost the case for his attorney. But that's just one small piece of the entire litigation.
So who do I turn to write the wording in a policy that's not going to get chewed up and spit out?
So quite frankly, any policy you put out there, a decent attorney is going to find some way to twist it. The most important thing is maybe not so much the wording, but just to ensure that all your policies are consistent with each other, and that it's one breathing document, as opposed to that copy paste thing we were talking about beforehand, where things might be contradictory, or just inadequate, or whatever it might be.
Okay.
And that it actually reflects what you're doing.
Right.
That is not like this. I always laugh with that safety comes first, because no, safety doesn't come first. If the safety really came first, you'd barely move the truck ever, because anytime you do it, you're
Mark, you almost stole something right out of my deposition preparation, where we say we have all different types of priorities, but I'll have plaintiff's attorneys say, what's the safest thing you could do? And the safest thing is that the truck didn't leave the yard. I mean, it's sarcastic, but it's true.
Yeah. And that, I guess, kind of leads into a question that somebody had below here. Would you recommend having a third-party expert review your safety programs to see where you sit with preparedness for legal situations?
Yes, 100% yes.
And I think we can connect you with some consultants that do exactly that. Tracy, if you're interested. Yes, we have a network of consultants that would love to help you with that. Yeah, very good. Okay. Go ahead, Rick.
We were talking earlier about things filtering down to smaller fleets, but how far down? So this question is if I'm running non-CDL drivers with box trucks, should this issue around the robustness of training, should a company like that be as concerned as, say, the larger like full-size CDL driving companies?
They should. When we get into the non-CDL world, obviously we're looking at it very differently as far as rules and regulations and things like that. But there's still going to be plaintiffs' attorneys out there who are going to then still look at the driving history of your drivers. If you've got somebody who just quite frankly has a lot of accidents, a lot of speeding tickets, a lot of whatever, that's a problem. But if you're also hiring non-CDL drivers, I mean, think about it. That means they didn't go through the training to get a CDL. So you're starting at square one. And it's still your company that is putting those people behind a wheel. And if I'm a plaintiff's attorney, I would have a field day just by essentially by misdirecting the jury, by talking about how all the training you didn't put out there. Because you didn't have to, quite frankly. There's no regulations that would require it. But that's not what a jury cares about, going back to the popularity contest. Right. So to wrap it up with the non-CDL, just hiring them and then putting them out there on the road is a very dangerous proposition. You need to have some sort of training consistent with the industry that they're in and what they're moving and how far they're moving it and everything like that. But I think that even with a non-CDL type of case, you're still going to have these same plaintiffs experts looking through everything and just talking about how unsafe it was to have them out there. So it's a kind of catch-22.
Right. There's another question here about the top 3 or 4 things that could be done sort of overall to kind of protect yourself. But I want to hold that off to the end because it's kind of one of those great summation questions. This one's for things like critical event reporting. From a litigation perspective, are you looking for documentation on paper that coaching occurred and was signed off by the driver? Or are details of coaching in the camera system enough, even if there's no signature from the driver?
The former. You never know when there is going to be a split in interests between the driver and the company. If that driver's terminated because of whatever occurred and they go rogue and they start saying, I was involved in this training or that training, how do you prove it? Unless there's documentation.
Fair enough. Let's see here. We're setting up driver kiosks so that online training can be done in the office. The rationale is that we then know for sure the candidate is the one doing the online training. And so, so what are others doing to ensure this? Is that, I mean, does that hit a threshold of best practice, or kind of however you're doing things, as long as you're documenting it, you can track it and you can prove that the training was done?
Yeah, documentation, proactivity. I mean, those are great things for a defense attorney to hear. It goes back to me telling the story of who that company is, who's running that company. And if I can put somebody up on the stand at a trial and confidently say that they did everything that they could, but the accident still occurred, accidents still happen, but they try to prevent it.
Right. And I would still add into that to follow up with those people after that training is done. I mean, you might be watching them there, but what are they getting out of it? And that's sort of an educational best practices thing, that they went through the training, they learned stuff, they maybe passed the test at the end. But if you have a discussion with them about it afterwards, it really gets buried in their head. It then becomes real for them in a whole different way. And that's going to be another part of the discussion that we had earlier about the follow-up and being able to show that you're doing everything you can to prevent it, to make sure that person really did understand it. You're not just assigning training and then checking a box that it was completed. You're following up to make sure that person actually learned and that their performance improved. I mean, ideally, you watch their performance on the road afterwards and you continue to follow up from them. But all of those things seem to go together into this cycle of continuous monitoring and acting based on that afterwards. That seems to be what I'm hearing.
Yeah, and to piggyback off that, Mark, dialogue from the drivers, so that they can actually demonstrate that they have not only absorbed the knowledge, but then they actually can apply the knowledge. That's really important. So not just can you remember how to answer these questions on a test, but let's talk about it. And that also might be an opportunity to bring in those more senior drivers to just facilitate more conversations, build that network within the company, and just build that company culture.
That's so funny that like all of the things that you're talking about just come back down to building a good company culture. Yeah. It really just always ends up at that, like getting people involved, giving a career path for your senior drivers, getting ways to keep them engaged. Yeah, it always comes back to the same stuff.
Because I guess I'll give you an example, Mark, of some of the companies I've represented that had bad company culture, without naming names. But going into their distribution centers or their warehouses, there's just a bad feeling in the air. Nobody wants to be there. It's simply a paycheck and that's it. And those are the type of drivers that are quite flippant when it comes to me questioning them about their training, about what occurred, things like that. That makes my job difficult. But if there is a driver who cares, and there are people above him who care, I can see that pretty fast when I'm visiting the client for the first time.
Okay. Yeah, that's great. Yeah, I really like that.
Here's a question. I'm not sure if it's a Kevin question or if it's a Mark question or both. Should online training be on duty time?
From a legal standpoint, yeah, I'm curious what your answer is there.
I don't think it has to be.
Yeah.
As long as it's trackable, provable.
Yeah. But I would put it the other way and say, if you're making drivers do training on their own time and not compensating them for that, doesn't that speak to profits over safety?
Well, so we're talking about two different things. We're talking about on duty and how we're defining on duty.
Okay, so they may be on duty and not being paid either way.
Right.
Okay.
So, not to go into the employment law side of it, but you do need to be worried about that, and make sure that you are following your local jurisdiction's laws when it comes to those things, and that's state to state. And I am not an employment lawyer, so I do not want to step into that one from that side of it. But from defending a company and everything like that, I don't think it really matters.
Okay. So the duty status in their logs doesn't matter that much, but it might make a difference if they were pushing people to do things and not compensating them for it. And then drivers were then saying, well, we don't really want to do it, or you're not seeing good completion rates or things like that. That's going to be a problem for you.
That could be a problem, right?
Right. So that's one of the other pieces that I would look at in there is, what are your completion rates when you're assigning online courses to people? Are they actually completing them? Are they doing things with that afterwards? Are you having those discussions? If there are problems and they're not completing it, if you've got a low completion rate, then maybe it is time to look at whether it's considered on duty, how it's being compensated, what you're doing as a follow-up. Yeah. Yeah, good questions.
Yeah. Someone else asks, is there any allowance being given to the fact that post-COVID, senior drivers don't want to do in-truck ride-along training anymore? I mean, for a plaintiff attorney, I suppose no allowance is given, but are we seeing some wiggle room in terms of the kinds of training that would be deemed acceptable or at industry standard or something like that?
So first I'll comment about COVID. There was a small window of time where juries really were siding with trucking companies because trucking industry kept Canada and the United States running during that time. Unfortunately, that time is come and gone. And trucking companies in general, as a commentary, are just considered big business, no matter how big you are. And there's just a general disdain about that. So if we are now taking that kind of a flavor that I'm at least hearing from juries, and then trying to explain to them, well, the senior drivers didn't really want to help out, but we had policies that they were supposed to help out with the ride-alongs and things like that, it falls right in the plaintiff's attorney's lap. It goes back into anything that's put out there by the company on their own. No one made them make that policy or to do that, and they can't follow through.
Right. Well, and also your earlier point about what the competition is doing. I mean, it ends up being a little bit of a sort of you've got to follow what everybody else is doing. So if others are doing something and you're saying we can't, well, that's going to be harder to defend, I would imagine.
100%.
Yeah. Okay.
What is the risk of having drive cam events for drivers that display bad behaviors, and the company not using these events to coach the driver to change these behaviors? So the company found out that they knew.
Yeah. So first off, I'm a huge proponent of drive cam, front and cab facing. I understand that can be received a little difficultly with the drivers, but that would be my suggestion, is having front and cab facing. Not utilizing the data, for example, the hard brakes or whatever that are reported, and not utilizing that is essentially just turning a blind eye. That is the theme that a plaintiff's attorney is going to use. So if you are buying the technology also, it is going to then tell the jury you've got the money to do so. And that verdict should be a little larger.
That's a great angle.
So if you've got the technology, which I absolutely implore you to do, utilize everything that comes along with it.
That's a great comment, because I see people that sometimes the answer is, well, we're just not going to do it at all. Like, if we don't have the drive cam, then nobody can ding us for not using that information. So it's that sort of willful ignorance thing. But that seems like that's not going to help either, because if lots of other people are doing it, why aren't you?
Yeah, and not to get too lost in the state versus state analysis, but some states, it would never be presented to the jury that you did not have drive cam. In other states, that would be presented that you did not have drive cam. So, and you can't pick, unless you're operating in one state or a couple states, you really can't pick where your accident that's really going to get the focus of a plaintiff's attorney is going to be.
Okay. Interesting.
Cool. What kind of liability falls on management in a courtroom when it comes to an absence of follow-up, in terms of following up on driver behavior?
Yeah, so a plaintiff's attorney will take the theme of, the buck stops where. Whose responsibility was it to do those things? And they will I mentioned safety director, but it doesn't end there as far as depositions and discovery and things like that. It could be the operations side, dispatch, all the way up to the C-suite if it's a large enough organization. And they're going to try and go as high as possible in that organization, president, the owner, whoever it might be, to make that person who's profiting from the operations, the person who's making the money, or at least they're going to make it sound as though everyone's making money in the trucking industry. They're going to paint somebody as the fall guy.
Right.
Mhm.
What's doing here?
Okay, so we are coming up on the hour, and the one thing that we had outlined right at the beginning that we were going to do, and I want to make sure that we get to it, is kind of summarize a lot of this into the sense of the ideal program. This is not going to be exactly what it should be, but the sort of high-level things to focus on that would be kind of the ideal program, and it comes to what somebody had asked about, the 3 or 4 things people could be doing. So I've sort of been taking notes as we've been talking, and I thought I would just sort of go through these of what I've been hearing over the past 50 minutes or so, and get you to comment on these and correct me. So first is the first thing that we talked about that seems to be number one is make it something that you can manage. Don't have this great plan that you're never going to be able to follow. I mean, and that comes with having consultants come in and tell you what to do. That's fabulous, but it has to be something that's reasonable for the organization. The second thing is going to be document everything that you do, whether it's online, classroom, yard practice, road training, follow-ups after cameras, all of those kind of things. Document all of that stuff, and get sign off wherever you can. That is going to be a big part of it. And that leads into following up. None of these things on its own is going to be sufficient. So you want to make sure that you're following up, having those conversations. We came back to that a few different times, whether it's trainers or using online stuff, whatever, but also keep it going. Don't end the training 3 months after the driver starts. You got to keep it going. Like you said, regulatory changes, technology changes, people just forget stuff. So you got to keep doing that. And then the idea of having sort of an outside reviewer, or having somebody to have a look at it to give you that fresh set of eyes, the expert review, comparing it with competitors, other fleets that are similarly configured. That's kind of a bit of a vague set of guidelines, but does that seem like the sort of direction that people should be following, the things they should be looking at?
It really is. And then from my standpoint, the one piece that I wish more and more carriers would really focus on and train is, what do you do when that bad accident actually occurs? And what I mean by that is your driver should be immediately calling somebody. And it doesn't even have to be a bad accident. It could be a little old fender bender, because sometimes those turn into the bad ones. But the training should include not only for the driver, but anybody else that's back at the yard, what should be done, who should be contacted when an accident happens. And your driver should also be trained to be essentially kind of like the first investigator on the scene. I don't mean going and talking to people and things like that, but reporting back of what's going on, how many vehicles are involved, law enforcement that's there, ambulances, this and that. That's the one thing that I'd love for everyone to take away from this is when you have that accident, what are you actually going to do? Have that train in place now, because adrenaline's going to be running and no one's going to be thinking straight when the accident actually occurs.
Yeah, well, it's a good point, and it reminds me of several years ago now when we built our accident scene course. It was at the request of our insurance partners, because they were seeing so many situations where drivers were just doing things that end up just killing them later when it comes to processing the claim. That it was like, please tell people to don't talk to the media, to don't be inflammatory on the scene, to document things, but don't remove anything, like the kind of basic stuff. But having people that are well trained in that situation can make a huge difference. Like you say, adrenaline, it's going to be a lot of shock happening. So making sure that people know what to do in that situation is very important. That's a good point.
Yeah.
Okay. Rick, any last questions or comments?
Oh, this was fantastic. I mean, to your point about training your drivers, the other bit of advice I recall is having your company have an actual crash event team, because that driver might be injured or that adrenaline's flowing. Have someone they can call who can then step into that role. Do you recommend that fairly robustly, or just have like, someone they can contact?
So I implore everybody, if they don't have that put together, do it now. These accidents don't always happen at 2 p.m. on a Wednesday. It's 2 a.m. on a Saturday. So you need to know who's calling who, and you need to have that team. So that's not only internally, but if you have insurance brokers, insurance carriers, if you have trusted counsel, you need to have all of them aware that they might be getting that phone call. It just really depends on what type of industry you're in and where you're running your freight and things like that. But you need to have those things ready now, because the other part of it is, what if someone's on vacation? I've run into that so many times, where a phone call or a voicemail was left on a Friday and someone didn't get it for a week. That's far too long. So you just need to have all those things sorted out now. Know what your playbook is now for when the unfortunate thing actually occurs.
When, not if.
When.
Right.
Yeah. Okay, I think that's going to wrap us up. So thanks very much, Kevin. Fantastic information, fantastic advice. Really appreciate that. Thanks for all of your questions. We will take these questions offline and see if we can get answers to them as well and distribute those. But the recording will be made available once we get it cleaned up. And thanks. Oh, hang on. I'm going to get in trouble if I don't do this. I have to have my closing slide up here. Yeah. There we go. We have our thank you slide that I get in trouble for not showing. Thanks, everybody, for attending. And yeah, look forward to getting the recording in your inbox shortly. Thanks very much, Kevin.
Amazing. Thanks, Kevin.
Everybody.